challenge in this appeal is to the order passed by a learned single judge of the Guwahati High Court on an application for review under Order 47, Rule 1 of the Code of Civil Procedure 1908, in short CPC. The application was filed by the respondent 1 for review of the judgment and order dated 21/8/2002, passed in second appeal number 12 of 1993. The second appeal was allowed by the High Court by the judgment and order reversing the judgment and order passed in title appeal 6 of 1990 and affirming the judgment and decree dated 19/1/1989, passed in title suit number 2 of 1987. Reference to the factual background as projected by the appellant in same detail would be necessary because the High Court has referred to the factual background to modify the judgment passed by the High Court in the second appeal and directed its dismissal. As a consequence, the judgment and decree passed by the first appellate court was affirmed and that of the learned Mansab in the title suit was reversed. 1. Mr. X, respondent 1 in the review petition, the original owner of the suit property, entered into an oral agreement with the appellant on 19/8/1982, and on the same day the appellant paid a sum of rupees 14,000 towards the agreed consideration of rupees 46,000 to sell his portion of the suit property with a dwelling house standing thereon. The possession of the suit property was also handed over to the appellant with a promise that a sale deed would be executed in favor of the appellant within 3 years. Again on 23/8/1982, the appellant paid a further sum of rupees 31,000. In essence of rupees 45,000 was paid, leaving only a nominal sum of rupees 1,000 to be paid at the time of execution of sale deed. At the time for execution of the sale deed was nearing, the appellant learned that the said Mr. X, with a view to defeat the appellant's right, was trying to sell part of the property to one Y and to mortgage part of the suit property with the Housing Board of Patna. He openly started threatening the appellant to dispose him of the suit property. The appellant paid the balance amount of rupees 1,000 and asked Mr. Y to execute the registered sale deed in his favor in respect of the property. In view of the threatened disposition, the appellant, with a view to protect his possession of the suit property, filed title suit number 2001 of 1985 along with connected miscellaneous case number 65 of 1985 inter alia, seeking confirmation of the possession over the suit land and premises, and for permanent injunction restraining Mr. X from dispossessing the appellant and from selling the suit property to any third party. In the said plant, the appellant expressly reserved his right to file another suit for getting the sale deed executed. By an interim order, Mr. X was directed to maintain a status quo in respect of the said property. The suit was dismissed for default, but later it was restored by an order passed by the learned Munsif. The appellant filed another suit, being title suit number 1 of 1986, for a specific performance of the agreement for sale and for execution of the proper deed of sale in respect of the suit property. During the pendency of the said proceedings, Mr. X executed and registered a sale deed in favor of one Usha Rani, defendant number 3, respondent 1 herein, while the possession of the suit property still remained with the appellant. Immediately thereafter, the appellant filed title suit number 2 of 1987 for cancellation of the said sale deed, as the same was illegal, fraudulent and void. Respondent 1 also filed a suit, being title suit number 22 of 1987, for declaration of her title to the suit property on the basis of the sale deed. Title suit number 2 of 1987 was filed by the appellant, was decreed, whereby the sale deed executed in favor of respondent 1 was cancelled. Against the said decree, respondent 1 preferred an appeal before the learned district judge, which was allowed, setting aside the decree passed in title suit number 2 of 1987. The appellant preferred second appeal number 12 of 1993 before the High Court. The second appeal was allowed, restoring the judgment and decree passed in title suit number 2 of 1987. By the impugned order, as noted above, the High Court held that no leave under Order 2, Rule 2 CPC was obtained by the appellant in title suit number 201 of 1985. Therefore, title suit number 1 of 1986, filed for a specific performance of the agreement for sale of land, is hit by the previous provisions of Order 2, Rule 2 CPC. According to the High Court, this is a case where review was permissible on account of some mistake or error apparent on the face of the record. In support of the appeal, learned counsel for the appellant submitted that the order of the High Court is clearly erroneous, completely overlooking the scope and ambit of Order 47 Rule 1 CPC. The parameter required for bringing in application of the said provision are absent in the present case. On behalf of the respondent, 1 Mr. Z, claiming to be the power of attorney holder, stated that the High Court was justified in reviewing the order in the second appeal, and the order does not suffer from any infirmity. He filed written argument signed by Mr. X stating that whatever was to be stated